Hi, I am attorney Chris Bathan-lasco. This is my virtual classroom. Welcome to my YouTube channel. In this channel, I shall aim to simplify the law. I will discuss concepts and principles of law in under 10 minutes.
Hello everyone, I know it's been a while, but I want to start off this video lecture after a very long hiatus with property law. So I want to talk first about ownership. So what are the rights of an owner pertaining to the property that he owns? Now this is a very long discussion, so I've decided to make this lecture into two parts. So this first video lecture will focus on what are the rights of the owner. What is his right when he enjoys his property? And of course, what are the limitations to this right? Now, of course, one of the rights of an owner is also the right to recover possession if he is dispossessed of his property. That topic will be in another video lecture, the second part of this video lecture, so that this video will not be very long, because as I've said earlier on, this is quite a long topic. So, after a long hiatus, let us begin this video lecture on property ownership. So, when you are talking about property, of course, you also talk about ownership of such property. Now, what is ownership? Ownership may be exercised over things or rights. So what does that mean? How do we define ownership? Ownership is an independent right of a person to the exclusive enjoyment and control of a thing, including its disposition and recovery, subject only to the restrictions or limitations established by law and the rights of others. So when you talk about owning something, it's your exclusive right to enjoy and control a thing, which also includes the disposition of the thing, and it also includes recovery of such thing if ever you are illegally dispossessed. Now, what are the rights of an owner? So if you're an owner, of course, there are rights attached to it. And you see that in Articles 428 to 430 and also Article 437. So 428 on the use, possession, and also the right to the fruits and also disposition of the thing that you own. So let's talk about the right to possess. What is the right to possess? It's the mere holding of a thing or enjoying of a right. It may be exercised in one's own right, or it may be exercised in the name of another, meaning you are possessing the thing not in your name, but you are possessing the thing in the name of another. In other words, you really don't own the thing, you are merely an extension of the personality of another, perhaps based on a contract. Now, does the right to possess include the right to use? Not necessarily. The right to possess does not always include the right to use. Just like a bailee in the contract of deposit. If you deposit something to the bailee, yes, they have the right to possess the thing, to safeguard the thing, but they cannot use it. So, while such person may have the right to possess, it does not necessarily mean that he has the right to use the same. Now, if you own a property, does it always include the right to possess? Also, not necessarily. Because, let's say, for example, you lease the property to another person. So, if you lease the property to another person, you may own the property, but you do not have the right to possess, because the person who has the right to possess is your lessee. Now, even your lessee can recover possession from the true owner of the property if he can prove that the rent is still existing, that he has paid the proper rent. So even that lessee can file a case against the true owner of the thing if he is dispossessed by the owner. So again, that just tells you that just because you own the property, that does not necessarily mean that you have the right to possess. Okay. The right to use and enjoy is also one of the rights attached to ownership. The right, of course, necessarily includes the right to transform and the right to exclude any person from the enjoyment and disposal thereof. For this purpose, he may also use such force as may be reasonably necessary to repel or prevent an actual or threatened unlawful physical invasion or usurpation of his property. Now, is there such a limitation? Is there a limitation to the right to use and enjoy your property? The answer is Article 431. It says, an owner, however, cannot make use of his property in such a manner as to injure the rights of a third person. Otherwise, he may be held liable for damages. The use of property has a social function to contribute to the common good. Of course, you can use your property in whatever way you want it. In fact, you also have the right to abuse it. You even have the right to destroy it. So for example, if you have a cellular phone, you have a mobile phone, can you destroy it? Can you throw it? Of course you can. That is your property. But if you throw it on somebody else's property, causing damage to somebody else's property, then you will be made liable for damages. There is always a limitation to an enjoyment of a right. And the limitation is that you do not violate the rights of others and that you also do not cause damage to the property of other people. So that is the limitation of the right to use and enjoy. The right to receive the fruits and accessories. Of course, if you're an owner, as a general rule, you have the right to receive the fruits and accessories. But of course, there are always exceptions. When are these exceptions? When are these instances when the owner is not entitled to the fruits of the property? When there is a possessor in good faith. Because you will later on learn in the chapter on possession that if you are a possessor in good faith, during the time of your possession in good faith, you are entitled to the fruits of the property. Okay. Another instance would be when the owner of the property has entered into a contract of usufruct or has granted usufructory rights over another, or two rather, in favor of another person. Usufruct meaning, and that's also another chapter in property which you will also study. Usufruct means that you are letting somebody else enjoy the property, the use and the enjoyment of the property, to the fruits of the property. So that's also another instance where your owner is also not entitled to receive the fruits and the accessories. Of course, another right attached to being an owner of the property is the right to dispose or to alienate. You can donate your property, you can sell your property, or you can use your property as a security for a loan, as in a mortgage or a pledge. Now, talking about the right to sell and the right to mortgage a property. May A sell property X to B when at the time of the perfection of the contract of sale, A was not yet the owner of the property, as it was still under a contract to sell between him and C. In other words, he is selling a property that is not fully his yet, because this property he entered into a contract with someone under a contract to sell. And if you can still remember, under obligations and contracts, if it's a contract to sell, the seller remains to be the owner of the property until full payment of the price. So this is the scenario. A is not yet the owner, as he is the buyer under the contract to sell and he has not fully paid yet. Can A sell that property to B? Okay. If you can still remember in your obligations and contracts, yes, the seller need not be the owner at the time of the perfection of the contract of sale. In other words, A here in our example can actually sell already, even if that is not yet his. The contract of sale is still valid at the time of the perfection of the contract. But of course, the law requires that at the time of the delivery of this property to B, he must already be the owner thereof. But at the time of perfection, it's not needed that he is already the owner. Okay, that's Article 1459. How about for pledges and mortgages? Will this same rule apply for pledges and mortgages? Meaning, can the pledger or mortgager pledge a property that is not yet his, but still under a contract to sell with a third person? Okay? This time, the law requires that the pledger or the mortgager must be the absolute owner of the property before he can mortgage or pledge the property. You cannot mortgage a property that you do not absolutely own. So it's a different rule in your pledges and mortgages versus the rule on sales. But then you may ask, attorney, how come I have come across a loan, somebody loans money, and then mortgages or uses as a security for his or her loan a property that does not belong to him? How come that is allowed or that is very prevalent in fact? Here, what they did was the owner of the property gave a special, or gives rather, a special power of attorney to the debtor. That the debtor, the one who is loaning or borrowing money, is now being given the power or the authority to use the property of somebody else as a security for the loan. So in essence, it is still the owner of the property and not the debtor who does not own the property. So there is no conflict to the rule or to the law that says that the owner, the absolute owner, should be the one who should pledge or who should use the property that he owns as security for the loan. Okay. Does the owner have the right to abuse his property? I've mentioned this already, and we said yes. You can even destroy it. Now, what is the doctrine of self-help? I've mentioned this a while ago. If you want to protect your property, you can do so. And that is the doctrine of self-help. That's Article 429. It says, the owner or lawful possessor of a thing has the right to exclude any person from the enjoyment and disposal thereof. For this purpose, he may use such force as may be reasonably necessary to repel or prevent an actual or threatened unlawful physical invasion or usurpation of his property. However, for you to use the doctrine of self-help, you must be able to prove the following requisites. First, you must be the owner or lawful possessor of the property. Second, you employed reasonable force. In other words, you did not employ force more than what was required in that situation or in that circumstance. Okay? Only that which is necessary to repel the invasion or usurpation, and that there must be no delay. Okay? It can only be exercised at the time of actual or threatened dispossession or immediately after the dispossession to regain possession. Okay? So, for example, you're holding your phone, you were walking, and then somebody snatches your phone. You can run after the snatcher, and you can use reasonable force. You could kick him a bit, or you could try to what do you call this? You could hit his arm so that he would release your phone. But you cannot use a knife to stab him. That is not reasonable force. And it must be immediate. You do not wait for a day to go after him. Because if there's delay, then you now let the courts decide your case. You do not take the law into your own hands. Okay. Once delay has taken place, even if excusable, the owner or lawful possessor must resort to judicial process for the recovery of the property. That's Articles 433 and 536. For he is no longer justified, as what I've mentioned, in taking the law into his own hands. Okay? And then another, of course, another requisite is actual or threatened physical invasion or usurpation. The right of self-help is not available against a sheriff attaching property in the lawful exercise of his functions, because that's not illegal physical invasion or usurpation. Okay? Now, the case of German management, this is where there were illegal occupants, but they have been there for several years. And then the owner of the property decided to bulldoze these structures. So what did the Supreme Court say about this? The Supreme Court said, although admittedly, petitioner may validly claim ownership based on the monuments of title it presented, such evidence does not responsibly address the issue of prior actual possession raised in a forcible entry case. It must be stated that regardless of the actual condition of the title to the property, the party in peaceable, quiet possession shall not be turned out by a strong hand, violence, or terror, because you have been there for a long time. Yes, you may be an illegal occupant, but it is not for the owner anymore to take the law into his own hands. And the doctrine of self-help is no longer applicable here, as those illegal occupants have been there already for several years. The Supreme Court further said, whatever may be the character of his prior possession, if he has in his favor priority in time, he has the security that entitles him to remain on the property until he is lawfully ejected by a person having a better right by action publiciana or action reivindicatoria. Okay? Okay, the Supreme Court here said, and you see there the highlighted statements. It said, such justification is unavailing because the doctrine of self-help can only be exercised at the time of actual or threatened dispossession, which is absent in the case at bar. When possession has already been lost, the owner must resort to judicial process for the recovery of possession. So here the Supreme Court said the action of bulldozing and destroying the crops of private respondents on the basis of the doctrine of self-help is no longer available to the owner because they have been there for a long time. It must be during the actual or threatened physical invasion that the owner should employ the reasonable force to repel your physical invasion or usurpation. But here, they're already there for several years. And so the doctrine of self-help is no longer available to the owner. Okay. Another right of the owner is the right to enclose and fence your property. Article 430, every owner may enclose or fence his land or tenements by means of walls, ditches, live or dead hedges, or by any other means without detriment to servitudes constituted thereon. And then you have the surface rights of landowner. The owner of a parcel of land is the owner of its surface and of everything under it, and he can construct thereon any works or make any plantations and excavations which he may deem proper without detriment to servitudes and subject to special laws and ordinances. He cannot complain of the reasonable requirements of aerial navigation. Now, when you talk about surface rights of the landowner, you own everything underneath it and you own everything above it. That's why you cannot classify a property as partly agricultural or partly mineral. Why? Because you cannot determine at what point underneath the surface will be mineral and at what point is it considered agricultural. Since your rights as a landowner is that you own everything above it and everything underneath it, it cannot have a hybrid classification. It has to be either agricultural or mineral. Another right of your landowner is recovery of possession and or ownership. What are the actions available to the owner if you are dispossessed? How do you recover possession and or ownership? If it's personal property, then it's rep levin. Okay? If it's real property, then you have several remedies available to you. You have the ejectment suits, the forcible entry and unlawful detainer. You have action publicana. You have action reivindicatoria. You have injunction. You have writ of possession. And in fact, so that ends our discussion on the rights of an owner of a property. I know I've ended with the last right, which is to recover possession. The continuation of that discussion will be in the next video because it's a very interesting topic. It's about how we recover possession if we are dispossessed, depending on whether it's personal property or if it's real property. So there's now going to be a discussion in the next video on forcible entry, on unlawful detainer. These are very important topics or principles that you have to learn.
So, if you find this video helpful, please click like, subscribe, and that notification bell so that you will be notified of new video uploads. Thank you for watching. See you next time in MBL Classroom.